Morning, colleagues and members on the platform. My name is Derek America Johan. I just don't see any other members on the platform. I know van der Westhuizen, he was part of another meeting that ends now. So are there any other members on the platform? Could you just advise, please?
Chairperson, I see member van der Westhuizen joined us. I just communicated with member Seleku, so he will most probably join us now as well, but I haven't then received any other apologies from member de Villiers or member Mbimbi.
Thank you. Anyway, we can then proceed, and as members join us, Honourable van der Westhuizen, I recognise you.
Thank you, Chair. My apologies. Unfortunately, the Programming Authority meeting that started at 8 o'clock is running over time. And I do know that the Honourable de Villiers and I believe the Honourable Seleku were also in that meeting. I have now joined on a second piece of equipment. So our apologies for a number of members that would be joining late.
No, thank you. I have sort of acknowledged your presence in another meeting and that you might join us a little late, and I'm happy that you were able to join us now.
Chairperson?
Yes.
Member Nkondlu has joined the meeting as well. She can just indicate whether she's standing in for member Mvimbi.
Sure, no, we will deal with that. Thank you so much. Yeah, I think we are, ready to go. So we will commence with the meeting, and as members exit another meeting and join this meeting, I would then welcome them. Honourable van der Westhuizen, is that a legacy hand, or is it a new point you'd like to raise? Maybe the mobile device, prevented Honourable van der Westhuizen from lowering his hand. Okay. Well, let us then start. Honourable van der Westhuizen, can you hear me?
Indeed, sorry, that was a legacy hand. I see on some of the apps, it lowers your hand automatically nowadays once you've spoken, but not on the one on my phone. Apologies.
Okay, no problem. Thank you so much, as long as you can hear me. So, colleagues, let us commence with this meeting. My apologies for all those present for trying to straighten out all these sort of little procedural matters before the official commencement of the meeting. But nevertheless, it is necessary. My name is Derek America. I am the chairperson of this standing committee. Today is the 21st of November, and this meeting is taking place virtually via MS Teams. This meeting is also a public meeting, and it will also be transmitted on YouTube, where the public can observe our proceedings. So, before I proceed, may I ask the members who are present to introduce themselves, and thereafter we will ask the officials who are in a meeting to introduce themselves and identify where they're from, and then who they represent, and then we take it from there. Honourable van der Westhuizen, I recognize you.
Yes, thank you, Chair. Just to confirm my attendance, Andreas van der Westhuizen, member of the committee.
Thank you, sir. Honourable Seleku.
Good morning, Chair. Good morning, honourable members. Isaac Mbulelo Seleku, member of the committee. Apologies for being late.
Yeah, your late arrival was contextualized in the sense that you were in another meeting. Thank you for joining us. Any other members who aren't present like to introduce themselves?
Morning, Chairperson. I'm member Nomi Nkondlo. I'm an alternate to this committee, but today I'm standing in for our main member, Member Mvimbi. Thank you, Chair.
Good morning, Honourable Nkondlo. Welcome to the meeting. Any other members who'd like to introduce themselves? Then I notice, thank you. So we are curated, so we are able to proceed with the meeting. I have also, Johan, before I ask the department and our guests to introduce themselves, did you receive any apologies from members?
Chairperson, the only apology is from member Mvimbi, but nothing else.
Okay, thank you so much. So now proceed to the other participants or guests on the platform, and I think we will start with the department. I've seen Ms. Moore on the platform. Ms. Moore, over to you.
Good morning, Chairperson and honourable members. Thank you for inviting us. I am Marissa Moore, the Head of Department of Mobility, and I am supported by a large team of officials. I have Bernie Magmahon, Acting Chief Director for Transport Regulation, with Mark Skryker, who's the Head of the PRE, Deirdre Ribbenaar responsible for transport operations, Farrell Payne for transport traffic management, and then also have Randall Barrero, who is responsible for transport administration and licensing, Ricardo Collins supporting Deirdre in transport operations, and then my team from the strategic planning unit leading with Kenneth Boyson, and he has brought Olivia and Pakama along in support. So thank you so much.
Thank you so much, Ms. Moore, for welcome, and thank you for your presence and your large contingent of officials. We welcome that. So then we also invited the National Department of Transport to be present and to deal with the matters that we're going to be dealing with today. Can I have an indication of who's leading the delegation and introduce their party? In any presence of the national department? Okay. Anyway, then I have the...
Good morning, Chair.
Good morning.
It's Kudu from the Department of Transport. Good morning, honorable members. I'm representing the team that will be presenting the transport. Mongezi Matebesi, who will be taking the committee through the presentation, and we should be joined by Katu Mudau as well. So that's the three of us, Chair. I thank you for the invitation. We'll be led by yourself as to when we should come in and present the topic. Thank you.
Thank you, sir. And then I've also noticed that we have Salga in the house. Members of Salga, would you like to introduce yourself?
Good morning, Chairperson. All protocol observed. I'm Loiso Siabonga Njamela. I'm responsible for intergovernmental relations in the Western Cape office. Apologies, we don't have the political representative. We are here as the observers. Thanks very much, Chairperson.
Thank you so much, Mr. Njamela. Any other interested party that have not been sort of acknowledged? And I see Ms. Shanaz, Syria.
Good morning, Chairperson, and to everybody present in the House. Shanaz Seria here. I am from the Department of the Premier, and I am from Branch Legal Services, and we supported the Department of Mobility with their preparation of comments on the Transport Appeal Tribunal Amendment Bill. Thank you.
Welcome, Ms. Syria. Thank you for your presence. Any other participant we have not sort of recognized or being made aware of your presence?
Sorry, Peter de Villiers here. I just came from the previous meeting of programming.
Thank you. Welcome, Honorable de Villiers. We were sort of informed that you were in the Programming Authorities meeting, and then you will be joining us late by Mr. Honorable van der Westhuizen. Welcome and thank you for your presence. Any other final?
Chairperson,
yes.
Romeo Master, Legal Advisor to Provincial Parliament and in support of this committee. Thank you, Chairperson.
Thank you, Advocate Master. Welcome also to this meeting, and we have Inati. Inati, will you?
Good morning, honourable members. I'm here with Mr. Lois Njamela. We've made presentations to the committee before as Salga. Thank you, Chair.
Thank you. Welcome. It seems as if now we have acknowledged and introduced everybody on the platform, and I think that we can then proceed with the business of the day. So, colleagues, as I've stated earlier, that this meeting is sort of conducted via the MS Teams platform, and as per the practice and the necessary protocols that we have observed over the number of years that we're using the platform, is that when the participants wish to bring anything to my, as the chairperson's attention, you can raise your hand or you can communicate via the chat function for me to, whatever it is, to be aware of. Secondly, it would be expected that those who make a contribution to the meeting could, if there's a wish, activate the camera, and would then be expected, and soon after they have concluded their contribution, disable the camera so that we could facilitate a sort of more seamless interaction, and thereby also considering the bandwidth of the communication that we are dealing with. This meeting, as I further earlier indicated, is transmitted, also communicated by MS Teams to the public at large that may have an interest in the proceedings of this committee. For members, as you know, if you experience technical or you need technical assistance, we have our technical technicians on the platform, or that's available to you, and that is Siraj Hassan, as well as Ms. Candice Morris. So those are the people that will assist you should you experience any technical glitches along the way. So all members and participants, I would urge you to mute your microphones to prevent any unnecessary distortion and disturbance when other members are engaging in the meeting. Once an applicant has concluded their input, you'll be expected that those participants switch off their mics and their cameras if they have activated those. And in terms of the order of the meeting, those directives were published on the 17th of April 2020, and I need not to verbatim state what it requires of members to do. So unfortunately, for this particular meeting, there is no interpreting services available, and should it be necessary for such services to be made available, I'm sure some of our members on the platform will gladly assist. So it would be therefore appreciated if we could conduct this meeting in English. And as I've stated, should there be an urgent need for members or the participants communicating in a different language, then certainly we will make provision for that. So back to the order of the day. Members were invited to this meeting, and the official invitation stated, amongst other things, that we will have a briefing by the National Department of Transport on the Transport Appeal Tribunal Amendment Bill. And secondly, this meeting will consider and adopt the final mandate report on the Economic Regulation and Transport Bill, the National Road Traffic Amendment Bill, as well as the National Land Transport Amendment Bill. And thirdly, we will adopt a number of committee reports. And then lastly, we will then formulate resolutions if there are any. Now, I need to, request the meeting to consider an amendment to the program, in the sense that item 2, consideration and adoption of the final mandate report of those 3 pieces of legislation that we've dealt with, should be sort of left in abeyance, or sort of eliminated from today's agenda. And the reason being that unfortunately the NCOP Select Committee on Transport have not concluded their deliberations. So them not having concluded their deliberations, unfortunately prevents us from considering our mandate, final mandate. And once that is concluded in the NCOP, then we will reconvene to consider the adoption of our final mandate. So members, please bear with me. Once we get notification from the NCOP that they have finished and we get the reports from the Standing Committee and the minutes, and then we can consider our final mandate. So hopefully it will be done in this term still, because we are dealing with very, very strictly tight deadlines, and we need to sort of put in the extra hours if need be to get things done. With that said, members, we were then issued with an amended agenda for this meeting. Excluding that, can I have a proposal that we accept the amended agenda in the sense that we will deal with the matters as stated, excluding the adoption of the final mandate for those 3 bills? Can I have an indication that we accept the amended agenda? Can I have a mover that we... Going once, going twice?
Support.
Hello.
Supported, sir.
Okay, thank you, Honourable Nkondlu. Can I have a seconder that we accept the amended agenda, and that being excluding the adoption of the final mandate? Okay, thank you, Honourable de Villiers. Okay, and so be it, and we will then proceed with it. So, colleagues, that brings us to the first item on the agenda, that, and the reason why we were all here, is the presentation by the Department of Transport, the National Department of Transport. The legislation and all the bills, as well as the PowerPoint presentation, was circulated to members. We will then have the National Department that will take us through all this particular amendment bill, and then we will open the floor for questions of clarity thereafter. Okay, so National Department of Transport.
Good morning, honorable members.
Okay. Thank you. Good morning.
I am Zongezile Mongezi Matebese. I'm going to make the presentation with regard to the Transport Appeal Tribunal Amendment Bill.
Thank you, sir.
Thank you, Honorable Chair. Now we're trying to slide it back to share it to the big screen. We'll go to that email. Honorable Chair and honorable members, we managed to flight it on the big screen. Now we are on page 1 of the slides, which talks about today's presentation on visual platform. Page 2 is the background, contents, background, main reason for the amendment bill, definitions, appointment of the TT members, extension of terms of office of TT members, fixing dates and time limits to implement TT decisions, directives to referral entities, suspension of decisions of referral entities, delays and frivolous actions. Continue on page 3, item 11, investigations by the TT, transitional arrangements, consequential amendment, consultation, impact
impact of 6 of Rail Safety Bill on the TT Amendment Bill. Lastly, point 16 is a conclusion. I'll continue, Chair and honorable members, on page 4, background. The Transport Appeal Tribunal Act of 1998, the Principal Act, was passed in 1998 to create the Transport Appeal Tribunal, TT. The TT deals with appeals relating to applications for operating licenses under the National Land Transport Act No. 5 of 2009, NLTA. These appeals are from the acts, directions, or decisions of the National Public Transport Regulator, NPTR, the provincial regulatory entities, PREs, in the 9 provinces, and the municipal regulatory entities when so established. That means MREs. No MREs have been established yet as we speak. Slide 5. Background continue. The TAT also does appeals relating to cross-border permits under the Cross-Border Road Transport Act No. 4 of 1998 as amended. Prior to the establishment of the TT, the National Transport Commission dealt with these appeals just as a short background, Chair. Slide 6, 2 main reasons for the amendment bill. Since its establishment, the TAT has encountered a number of problems and issues which require amendments to the Principal Act. The Principal Act also requires updating in respect of the development since 1998. There are also some technical issues that need amendment to the Act. These problems and issues are addressed in the TAT Amendment Bill, B8, B 2020, and elaborated below. Consequential amendments are also made just to align with the processes that are unfolding with regard to the public transport sphere. Slide 7, 3 definitions. Clause of the Bill 1, section of the Act 1, amendment. Redundant definitions such as board, interprovincial transport, and national land transport legislation are deleted from the Principal Act. Board has been the purpose of the amendment. The board has been replaced by a regulatory entity in the NLTA. Intra-provincial transport was only relevant to provincial appeal bodies which no longer exist. National land transport legislation was included because such legislation had not yet been enacted in 1998. It is replaced by reference to the NLTA. As I'm saying, this is trying to align 1998 and the current sphere. 1B, Section 1, a new definition of the Act direction or decision is inserted. This clarifies and expands the Act's directions or decisions which are subject to appeal by the TT. The purpose of the address. Sorry? Hello? Oh, sorry, sir. Chair, the purpose of the address is to, the purpose is to address doubts expressed about this during hearings. As I'm saying, is trying to align with the realities, because in the hearings, there are some, whether the TT is applicable to Section 79, Section 78, and everything. Those new definitions are trying to address those processes and related. Slide 8, Clause 1B, Section 1. A new definition of the Cross-Border Transport Act is inserted. Makes it easy to read the Principal Act and to standardize the same definition of the NLTA. As I'm saying, it's trying to align the new with the current situation. A new definition of land National Land Transport Act inserted. It will replace the general reference to land transport legislation. Definition of regional community amendment, consequential amendment. A new definition of regional entity inserted to standardize the definition of the NLTA. Slide number 9, clause of the Bill 2B, Section 4.2 of the Principal Act Amendment. The amendment bill will provide that TT members must have expertise in public transport matters. Purpose: the Principal Act does not provide for the appointment of members with expertise in public transport matters who should be cured by the amendment bill. Such expertise is considered necessary. We'll try to take out the requirement for finance and replace that with the requirement for public transport in the amendment bill. Slide 10, clause 3, section 7.4. Amendment. The amendment bill will allow the minister to extend the period of office of TT member for a period not exceeding 12 months. Purpose: under the Principal Act, TT members must be appointed for a fixed term not longer than 3 years. It is sometimes expedient to extend the terms of office of individual members, e.g. to enable them to deal with matters that are partly heard or incomplete because of their knowledge, insight, or preserve institutional memory of the matter, so that the matter can be finalized by the people that they have started it, but yet mostly matters. Number 11, slide 11, clause 4, section 9.9, subsection 1. The Principal Act will be amended to provide that the Director General of the Department must fix dates, times, and places for hearings of the TT after consulting the TT. The purpose, it is better for the DG to fix dates, times, and places for hearings so that the necessary administrative arrangement can be put in place timeously, subject to budgetary considerations. The department is responsible for the budget, staff, and resources of the TT. This amendment is made in response to comments received. 12, clause 6E, section 12, subsection 4, and subsection A. The amendment bill will empower time limits to implement the TT decision. The amendment bill will empower the TT to impose time limits within which its decision must be implemented once it has made a decision. Purpose, sometimes when the TT takes a decision imposing duties on the parties, such as the regulator entity, it is advisable for the TT to impose time limits for performing the duty to ensure implementation of the TT's decision. It's just an admin process because TT don't follow its decisions. Now, once TT made a decision, the TT ends, but now the appellant, so to speak, the appellant will come back after some time, alleging therefore that a certain entity is not implementing the TT decision. Then we are trying to put the timeframes to that process also. 13.8 directives to regulatory entities, 6F, section 12.5, subsection 5 and 6. The amendment bill provides that where a regulatory entity or the regulatory committee failed to comply with the decision of the TT may issue a directive describing the failure to comply with the obligations and state steps that must be taken to meet the obligation. The entity must then comply with the directive within the time specified. It also provides that when such a directive is issued, the TT must notify the minister, relevant MEC, or mayor of the municipality, as the case may be, so that they can assist in assuring compliance with the directives. Purpose. It often happens that regulatory entities fail to implement or give effect to a ruling or a decision of the TT within the time specified by the TT, or within a reasonable time, or at all. The amendment will facilitate compliance to that. As I've indicated, Chair and other members, therefore, that TT don't follow its decision. Now, if that happens, that the TT is not implemented, we are trying to invoke what is called intergovernmental framework processes, so that other offices can come and assist the TT to assist the appellant at the end of the day to get what the TT has suggested in its decision. Slide 14.7b, 13, section 13b, amendment, suspension of decision of the regulatory entity. The amendment bill provides that a decision appealed against will be suspended automatically where an appeal is lodged with the TT within 30 days. A consequential amendment is also made in section 13. This will expedite procedures in that appellants who appeal to the TT within 30 days will not have to lodge a formal application to suspend the entity, which is the common law process that is applying to the courts actually within the Republic. Slide 15, delays of and frivolous actions. Clause 8b, section 14, subsection 5, amendment. The amendment bill will allow the TT to investigate any delays of frivolous, vexatious, or irrelevant actions taken by parties to an appeal and take certain steps to counter them as listed in the bill. This clause also makes consequential amendment to section 14 of the Principal Act. Purpose. It sometimes happened in the proceedings before the TET that parties deliberately delay the proceedings. For example, where the TET is likely to have an adverse effect on the finances of the party that caused the delay. Parties also sometimes engage in frivolous or vexatious or irrelevant actions, either to cause delays or for other reasons. These actions not only waste the time of the TET and cause wasted court, but also unfair to the other party or parties to the appeal. In any judicial processes, chair and honorable members, there is a principle of finality. The TET now is trying to say, if we receive a notice of appeal and attended the appeal, it has to be finalized and be over. There's some deliberate delay to the processes. And take to account, Chair, therefore, that TET members are not permanent. They come as per the appeals that have been noted by the general public to the department. Slide 16, clause B9, section 16, subsection 1, investigation by the TET. The Principal Act provides that the DG must appoint officers in the duty to perform administrative and sectoral work of the TET. The amendment bill will also permit such staff to be appointed to undertake investigations that are necessary for the TET to reach its decisions. The Act is also amended to remove the requirement for the DG to consult the TET before appointing staff. Purpose: the TET needs to be able to conduct its own investigation and require staff and resources to do so. It has proved unnecessary to require the DG to consult the TET before appointing the staff. As it was stated, Chair and members, therefore, that the TET appointed through a TET Act, and the secretariat that supports the TET is appointed through the Public Service Act. The officials of the department appointed permanently to provide secretariat to the TET. Slide 17, transitional arrangements, clause 11, section 18, amendment. The amendment bill amends section 18 of the Principal Act and affects constitutional amendments. The reference to National Land Transport Legislation in the Principal Act is replaced with the reference to the Transitional Act. This is a consequential amendment necessitated by the fact that the definitions of board and National Land Transport Legislation are being repealed. Purpose takes into account the development since 1998, as alluded earlier, Chair and honorable members. Whereas the amendment bill affects consequential amendments to the Principal Act. These amendments are necessitated, for example, by the fact that some definitions have been changed. That's the alignment as it was stated before, Chair and honorable members. Slide 19, consultation. The amendment bill was published for comment in the Government Gazette on the 27th October 2017. A national workshop was held on the 26th February 2018 with government stakeholders. A national workshop was held on the 27th February 2018 with private sector stakeholders. The following were consulted during the workshop: the National Public Transport Regulator, the Cross-Border Road Transport Agency, the 9 provincial retailer entities. Consultation continue. The 9 provincial departments responsible for transport: the South African National Taxi Council, the National Taxi Alliance, the Southern African Bus Operators Association, the South African National Small Bus Operators Association, the Meter Taxi Industry and Electronic Hail Operators, and the Transport Appeal Tribunal members. Consultation continues. Slide 21. Written comments were received from the following: the Provincial Minister of Transport and Public Works, Western Cape, the Cross-Border Road Transport Agency, the City of Cape Town's Transport Urban and Urban Development Authority, and Railway Safety Directorate of the Department of Transport. Slide 22, consultation continue. The amendment bill was tabled at the Economic Development and Labour Council, NEDLAC, Socio-Economic Impact Assessment System, SESAS, as conducted by the Department of Planning, Monitoring and Evaluation. Economic Sector Employment and Infrastructure Development Cluster was consulted. The amendment bill was introduced to the National Assembly on the 29th May 2020. The amendment bill was approved by Cabinet on the 12th February 2021. The amendment bill was presented to PCOT on the 25th August 2021. Subsequently, the PCOT publicized the amendment bill for public comments with the closing date of 8 October 2021. Furthermore, on the 7th December 2021, PCOT considered the list of written submissions received. Slide 23, consultation continue. On 1 March 2022, PICOT held a virtual meeting to deal with the received 2 comments on the amendment bill. Consequently, the TT Directorate responded to the received comments and forwarded its inputs to the Duty Legislation Directorate on 4th July 2022. Therefore, on the 1st November 2022, the PICOT invited the department to its meeting to consider its responses from the received 2 written submissions, and the department responded accordingly, and the emerging impact of Clause 56 of the Rail Safety Bill B7 2021 was also presented and deliberated. At the end of the PICOT meeting, it was stated that the department will be advised on the way forward regarding Clause 56 of the Rail Safety Bill with regard to the TT amendment bill processes. And furthermore, on 15 November 2022, the PICOT invited the department to its sitting to consider the TT bill clause by clause, whereby most of the clauses were agreed upon and adopted for amendment, except the one dealing with the consultation of the MECs in the Principal Act. That one was refused, was not supported. Slide 24, item 15, impact of clause 56 of the Rail Safety Bill, B7 2021 on the TT Amendment Bill. The memorandum of the objects on the object of the Rail Safety Bill provides as follows. Clause 54 to clause 55 provides for the appeal mechanism against any decision by an employee of the Rail Safety Regulator or made in the name of the RSR. Full stop. The first level of the appeal is to the CEO in terms of clause 54, then to the Board Appeals Committee in terms of clause 55, and ultimately to the Transport Appeal Tribunal in terms of clause 56, established by Section 3 of the Transport Appeal Tribunal Act 1998, Act number 39 of 1998, the Principal Act, which is to be amended by the Transport Appeal Tribunal Amendment Bill B8 2020. Which is currently being called our emphasis of the Rail Safety Bill. Furthermore, it was resolved on 15 November that Clause 56 of the Rail Safety Bill will not be incorporated on the TT Amendment Bill processes, as the bill is not yet an Act of Parliament. Number 25, impact of clause continues. 56. Consequently, the final advice from the Parliamentary State Law Advisor was the insertion of the new provision in the TT Amendment Bill that will accommodate public transport legislations or similar legislations that might refer their appeals to the to the Transport Appeal Tribunal. The said provision has been inserted in the Transport Appeal Tribunal Amendment Bill B8B 2020 as thus, or any relevant transport legislation as the case may be, which should now be a sweeping or accommodative clause in the TT Amendment Bill, so that any bill that might come that will request, therefore, that the TT must hear its appeals. It will fall within that bill and be taken further with the TT processes as it's presented. Conclusion, slide 26, item 16. The report on the TT Amendment Bill was on the other paper of the National Assembly, where it was deliberated upon and passed by the National Assembly on the 7th March 2023 and referred to the Select Committee on Transport, Public Service Administration, Public Works and Infrastructure. In accordance to the status of the parliamentary processing of the on bills at 2023 5th Session 6th Parliament dated 8 September 2023, it indicated that the TT Amendment Bill B8 2020 is with the NCOP as of 7 March 2023. Last slide, last number 27, the end. To process the Transport Appeal Tribunal Amendment Bill further in accordance to the procedure established in Section 76 of the Constitution, the ultimate enactment of the TT Amendment Act is crucial in regulating public transport in the country. I thank you, Chair and honorable members.
Thank you, Mr. Sikudu, for the presentation. Just for clarity purposes, nothing that was reference was made to PICOT for those who are not familiar with the abbreviation. I think that stands for the Portfolio Committee on Transport. Is that correct, Mrs. Kudu?
That is correct, Chair. That is correct, Chair. Thank you.
Thank you, Mr. Sikudu. Okay, Now, Mrs. Kudu, you may, yeah, I'm going to open it the floor for questions of clarity, for comments from members, because this is the beginning of the process to deal with this amendment bill. So we will have ample engagement with the department and other stakeholders as we move forward. But for today's briefing, we're going to restrict questions for clarity and comments, and I don't think the department would make any comments at this stage with regard to the bill, neither our legal advisors from the Premier's office, as well as the committee's legal advisor, Advocate Marstorp and Salga. So I recognize Honourable van der Westhuizen.
Thank you, Chair, and thank you for the presentation. Just a few questions from my side. The first one is an interesting comment that I've picked up, where you've said that there have been no municipal regulatory entities established under the National Land Transport Act of 2009, where I see that that act says that, you know, some of the regulatory functions can be delegated or devolved to municipal level. Perhaps if you could just tell us perhaps why that has been the case, and you know, why did you feel it necessary to highlight the fact that up to now municipalities have not been establishing such entities? Is it because you know, is it the chicken egg situation? They don't establish those entities because they have not you know, received the mandate to issue operating licenses, or, you know, is it the other way around, that you cannot delegate because there are no regulatory entities? And then on your slide 23, if you wouldn't mind perhaps just quickly jumping to that, you said that there were some consultations regarding the amendments. That your last sentence there says in November 2022, the PCOT, the Portfolio Committee on Transport, invited the department to its sitting, and then you went through it clause by clause. When most of the clauses were agreed upon, is my interpretation that therefore the Portfolio Committee, you know, you say were in support of that and adopted for amendment, except the one dealing with the consultation of the MECs in the Principal Act. Perhaps if you could just explain to us, is it the fact that the consultation with the MECs was to be removed, or what may be the situation there? Thank you, Chair.
Thank you, Honourable van der Westhuizen. Any other member comments? Maybe I could simply just add an additional sort of question for clarity. Mrs. Kudu, I think in clause 3, provision is made for the extension of a member's term of office by a period not exceeding 12 months, and that is, you know, it's logical in the sense that if part-heard matters are to be concluded, those who have dealt with the matter and have knowledge and experience of dealing with the matter should conclude that matter, and that will eliminate unnecessary delays. But it states not exceeding 12 months. What would happen if a particular matter that is being considered is not concluded within that extended period of time? Would there be a mechanism to extend it further, or could we perhaps not have considered phrasing it in a way that that the extended period of time should be linked to the finalization of a matter under consideration. Thank you, sir. Any other member would like to ask a question of clarity, comment? Mrs. Guru, over to you to respond to those 3 questions.
Thank you, Chairperson. Let me correct the Honorable Chair. The presenter was not Mr. Moikesi Skudu. Our Chief Director was Zongezile Mongezi Matebese, who's the Director responsible for transport appeal processes, our Directorate in the department. I just want to make that clear so that the recording cannot be misled at the end of the day. Thank you, Chair. Let me now come to the 3 questions that have been asked. The first one is about the MREs, as to if the NLT is saying there should be MREs, why they are not. I think that number 1, a disclaimer is therefore that that question is not within the mandate of the TT Directorate. It's within the mandate of the Department Public Transport. But now there are processes that the municipalities must be taken care of. That means the allocation of the budget, of the funds, and everything that goes with the process, and the readiness of the municipalities. But on that one, I cannot go further than that because it needs the department to engage with the municipalities for the municipalities to have them. I was just stating the status quo that as we speak now, there's currently no established MRE, but there are processes to establish the MREs within the department and the municipalities. Thank you, Chair, on that score. Number 2, Chair, the question of the slide 23 with regard to the MECs. Thank you, Honorable Member. The initial amendment was to remove the minister to consult the MECs when appointing the TT members. The understanding was that the TT appointment is a national duty vis-a-vis the provincial entities with a provincial mandate. Now, that the scope of the appointment falls and ends on the minister, not on the MECs, as the minister is also not party to the MECs appointment of the PRPs. And also, although it was a little bit of an administrative nightmare, because we forward documentation to the MECs and then there's no response with regard to the request for their comments and engagement in the matter. But now, having that view initially on the principal or on the initial amendment, the portfolio committee didn't support the view. The honorable members of the portfolio committee didn't support the view of the removal of that provision of consulting the MEC by the minister when the minister is making an appointment with the TT. Then now, it means therefore that provision still sustained in the principal act of the TT. It's still there. It has no longer picked up. But all other amendments, the portfolio committee agreed with. That was the intention of, if you read the clause 9 and 23, no, sorry, 9 is about the expertise. If you read clause 23, that's what we're trying to say. Everything was accepted by the portfolio committee, bar the removal of the MEC, which now it reverts back to the original status. The minister has to consult the MECs when appointing the TT members. We continue the principal act as it is. Thank you on that one. On the slide 10, with regard to the 12 months, honorable members, that scenario came to the thinking of the TT Directorate to say, what if something happens after 12 months? But the understanding is that members of the tribunal are appointed for 3 years. Now, the 1 month period, it can necessitate, according to our judgment, value judgment, it can necessitate all other matters that are for the TT to be finalized. Actually, we strive to finalize matters as they are, and not to have the bad head matters being rolled over, more so when the term of the members is coming to a close. But the cautionary process is that once you extend, you keep on extending from 12 months. 12 months is a year, and the permanent members are appointed for 3 years. Now you extend that 12 months for about a year or so. You put another month, 4, 2, 3, whatever. Now you are running a risk of running 2 parallel structures: the permanent structure of 3 years and the other structure of 1 or 2 people who have happened to be finalizing a particular matter. The purpose is to not have budget matters being rolled over after the term. That's the purpose. But if that happens, at least 12 months will be able to cater for that eventuality, so that we don't have the risk of running 2 parallel structures within the TT processes. That is the rationale for limiting it, Honorable Chair, to 12 months and not exceeding 12 months. At least to us, that 12 months is a reasonable period for any other matter that might have been, although we're trying to avoid exactly that. But if that happened, any matter that has still pending budget shall have been attended to 12 months. Thank you, Chair and honorable members.
Thank you, sir. Members, any other follow-up questions you'd like to ask? Can I get an indication if there are any other, I know that the department might be a little restricted in terms of engaging the national department now. But from SALGA side, any questions for clarity that you'd like to pose?
Thank you, Chair. Thank you. Chair, we do note Mr. Matebes's point about no MREs currently. He's right. I think that would require an extended process to capacitate municipalities to be able to establish those MREs. However, Chair, there's a concern a bit about the clauses of the amendment bill that empower the DG to determine the dates and places where meetings of the TAT should happen, and how that relates to the independence of the TAT. Because I think part of the founding principles of the TAT is that the TAT must be independent from the department. So it's quite a concern when now the TAT, for the TAT to have a meeting, the DG must give an okay for that. I think that for us as SALGA is a serious concern in that regard. I think I would even be more acute and say I think it's a regression on the progress that we've made to ensure that institutions of appeal, because these are judicial institutions, because that's what the appeal tribunal is. Because it makes decisions. So those decisions should be made without any undue influence from the department. I suppose the earlier point also raised about the very appointment of the members of the TAT is also, I think, a relevant and important matter. So I think, Chair, in that regard, and the challenge we have is, I think, as SALGA as well, is because there are no MREs currently. We've not been included as a stakeholder in the consultation of the bill on the premise that there are no MREs. But on the other side, in the project that the department is doing to try and establish MREs, we're being consulted. So the assumption is that once MREs are established, the decisions of the MREs will be subject to the legislation that is being passed. So I think there's a bit of a gap in that regard, in that SALGA, we've even though the intention is clearly to establish MREs where possible, we've not been consulted in how this amendment bill will function. Even the matter that I'm raising about the independence of the tribunal is a matter I'm raising based on the presentation that I've been exposed to today. So we have no prior engagement with the department on this at all. So I think that might help us as SALGA if that were to happen, Chair. Thank you so much.
Thanks so much. Yeah, thank you so much, Salga, Mr. Mtonchi, for your sort of comment. I just noted that Ms. Nkonlu has raised her hand. Honorable Nkonlu, over to you.
Thank you, Chair. I just have one question I would like to ask. It pertains to the consultation process. If I heard the presenter correctly, actually it started with the stakeholders. And when I listen in the presentation to most of the submissions made, my take, if my categorization would be correct, is that predominantly submissions that have been received in this process would have included in the main a government, whether in the form of departments or government founded institutions. Because in the stakeholders, I listened to the fact that stakeholders identified would have been the taxi industry, your e-hailing, and the related. And I didn't hear that any submissions were received. If that could be clarified to me, and if not, if such is not a concern, particularly because this is a stage at which, if any of these stakeholders, as those affected by the transport legislation, are not happy, then this becomes a platform for recourse for these stakeholders. So I'm interested if that is not a concern, and if there's any discussions, if indeed my assumption is correct, that not much submissions were received from these particular stakeholders that are non-government by definition. So I just wanted to understand that, Chair, from the presenter. Thank you very much.
Thank you, Honorable Nkonlu. Any other comments or any other participant in the meeting? Yeah, over to the National Department for responses, please.
Thank you, Chair and honorable members. Let me start with the SALGA comment and concern or question. I think it's a concern. The MREs, he made a comment, the same comment that I've made. But now the question of slide 11, where now the DG is to be in charge of fixing the dates and the places of the tribunal sitting. Chair, this came out of the realities of the realization, therefore, that the TAT budget is with, number one, TAT is not part of the entities that are mentioned in the PFMA, where now those entities like cross-border and related ones have got their own budget that they for operational purposes. TAT is located within the department, but independent of its processes within the department. But the secretariat is for the department. Now, the understanding was that because the DG is the ultimate financial financial person of the accounting officer of the department, it makes sense now, therefore, that the DG, through the chairperson and the secretariat, will be informed and be allowed to agree on the process that is going to be taken with regard to the hearing of the matters. What we normally do is that there's a schedule that we normally develop by the chairperson for annual schedule, the chairperson and the secretariat that is presented to the DG, so that to the DG, to the DDG, to DG, to our DDG for DG, so that whenever there are hearings that are going to happen, we tap into that, and then and there was no any situation where the TAT was not as a structure was not was stopped to attend to any particular hearing. But the cautionary rule is therefore that if now the TAT will decide on the person of not being known on the budgetary constraints of the department and the government generally, now it will give in unintended consequences, some friction between the Transport Appeal Tribunal and the department. So now we're trying to handle the processes so that the two structures assist each other, and the head of the financial of the department is the one that should be responsible for the approval of the traveling of the hearings of the tribunal. But this has got nothing to do with the tribunal hearing of the matter per se. This is about the tribunal coming to the department or going somewhere. This independence that can be, so to speak, be affected. It's a question of managing the processes, the traveling or not traveling. But as I'm saying, we have never had a situation where the department refused the tribunal to go to any particular place, but we are trying to formalize the process. On the question of consultation, we did meet with SALGA through NETLEC processes on the amendment bill when the bill was in the early stages. SALGA was there. It was through NETLEC processes. I'm trying to say SALGA did know about the processes. On the question of the consultation with other non-governmental stakeholders, we did invite them. Consultation was held as stated in the amendment bill. In the presentation, consultations were held, but we received two. There was verbal interaction during the stakeholder management sessions, which we captured. But the formal response came from the two governmental institutions. Although we had consultation with non-government and non-governmental structures. Yes. Chair, sorry. I'm trying to the ones that we said, Chair, will receive comments on slide 21. Western Cape Provincial Government, cross-border, City of Cape Town, and railway safety. Those are the ones that we receive comments on slide 21 of the presentation that we've made. Thank you, Chair and all members.
You have any other follow-up questions? I think Salga has a follow-up question for clarity. Salga, over to you. And Kondlu, is that a legacy or is it a new?
It's a follow-up, okay?
Follow-up, thank you. Right, over to Salga and then Kondlu thereafter.
Thank you, Chair. Two things. I'm not sure if I hope I understood Mr. Matibisa very well. He seems to suggest that there is no problem. In other words, there was no instance where the tribunal had to meet and it couldn't meet in the current arrangement. In other words, without the amendment to make the DG responsible for this. So in simple understanding, there is no problem from what I hear him to be saying. Secondly, I think the issue of meetings, it speaks to the same issue that he was trying to relating in the presentation about delays and other issues. So when a matter has to be heard, it's not just whether the merits of the matter, but it's also the delays around the matter. So if there's a disagreement between the DG or the DG does not think the meeting should happen, or the DG thinks the meeting should happen elsewhere, the tribunal thinks the meeting should happen somewhere else, the DG effectively has veto rights on that. So it's not just the issues are not just about the merits of the matter at the discussion of the matter, but it's also about the whole logistics relating to those matters. So as far as I'm concerned, the independence does not only relate to the actual merits at the hearing of the tribunal, but around all the issues around the meetings. If a matter, let's hypothetically and maybe be cynical as well, and I apologize for that. Let's say, for example, the DG, there's a matter that he has an interest in, and it serves the interest of the DG or whoever is related with, that the matter is not heard. So the DG simply does not agree on the venue, and the matter is delayed. So I think it's important, I think, to legislate when necessary and legislate not according to who the incumbent DG is. It might be that the DG that's there is a very good DG and this problem will not happen, but we can't legislate based on behavior of an incumbent. We must legislate for all possibilities. Then on the issue of consultation, I do not agree that SALGA can be consulted through NEDLEC. It might be that SALGA is a member of NEDLEC, but that's for other purposes. If the intention is to consult SALGA must be consulted directly, as is the case with other stakeholders. I didn't get the impression that other stakeholders were consulted through NEDLEC. I didn't hear maybe a view that says Santaco, the DOT met with Santaco at NEDLEC. No, my understanding is that the DOT met with Santaco directly. So the expectation that a proper consultation with SALGA must happen with SALGA, not through NEDLEC. So even in that view, we as SALGA, we don't agree that that is appropriate type of consultation. Thank you, Chair.
Thank you, Mr. Mtaninsi. Honorable Nkondlu, over to you.
No, thanks, Chair. I think on the matter of consultation, you know, as a very important democratic principle held in our constitution to enable sufficient public consultation and inputs to lawmaking in South Africa, a very fundamental shift from the previous dispensation to this one. I think for me, it becomes very important, Chair, whilst taking into cognizance the response given, that a hearing would be put out and on the basis of those that respond or not respond, you know, we as government or those that are responsible to lead and facilitate public hearings or public consultations, we would then take it, you know, that look, from where we're on our side, we've complied, but I think the test must always be the extent to which those that are directly and even those indirectly affected gets to input on processes of this very important nature. And I'm raising this, Chair, as yes, a general point, but specific in this regard, that it is a concern to me that stakeholders such as the taxi industry, e-hailing and others, and I think SALGA is raising its own plight on the matter, that this is something that we should not take for granted, because I think all of us know that there is case law, you know, where government has been taken to court on the matter of sufficient consultation, especially on those that would be affected. And it is my firm view that where we as practitioners or those responsible for processes, that where we do not find that it is our responsibility to go an extra mile to engage these sectors. And I'm raising this also, Chair, beyond that, on what we see on our roads, you know, the kind of challenges where there is true carnage on our roads, you know, a protest and all of that, that you find that there is serious challenges between those that are affected by our transport legislation versus what we supposedly to be the law. And therefore, it is in our interest, you know, to ensure that those that are in that particular space, even on technical legislations like this one that relates to things that would believe are more of logistical arrangements of establishing, you know, somewhat proper or harmonious processes, I think it becomes important. And I'm raising this as just a general point that I'm placing to the department from where I'm sitting, that one of the things that one looks at is actually the process at which we arrived at the outcome which we believe has been consulted, you know, through public consultation to get at the final product, which will then legislate. I think that's just an issue that I wanted to raise, because I believe that these stakeholders that are outside, you know, of ourselves as government and department government through departments and ourselves are very important to ensure that we go an extra mile to ensure that there is record and evidence of their input into the process. Thank you very much.
Thank you, Honourable Nkondlu, for that contribution. Over to the National Department for responses.
Thank you, Chair and honourable members. I think on the department has noted the comments and concerns of SALGA, and I think the department can engage with SALGA further on the processes while the process on the bill for them to finish their comments thereof, while the process is still within your good self, Chair, and the committee. And on the question of sufficient consultation, I think we have done that, but it doesn't mean therefore that we cannot do it better, because we have consulted the industry, which is part of SALGA, SANDACO and NLTA, NTA and other structures, the mother bodies. We have done that, but it doesn't stop therefore that we cannot go further if there's a concern for the department to go further and consult with them. I think, Chair, that's a response from the department. Thank you, Chair and honourable members.
Thank you. That is a good diplomatic response. Thank you so much for the responses. I'm just going to, for one last time, open the floor for any comments or further questions for clarity or follow-ups. Okay. Thank you. It doesn't seem as if there are any further questions for clarity. Let me state that this is just the start of the process in our committee. I think our members received the Principal Act and Amendment Bill just less than a week ago, and there's lots to digest and to consider. I'd like to thank the National Department for giving us this briefing this morning and responding to the comments and questions of members and stakeholders for clarity. I think it is just the beginning, and it will certainly assist us in formulating our mandate as we go forward. With that said, I am going to thank the department once again for being present and responding to the questions. I would like to express my appreciation for our other partners in the legislature, that is the Parliamentary Legal Advice Advocate Master and from the Premier's office. Furthermore, I'd like to express my appreciation that the department, under the leadership of Ms. Moore and a number of senior personnel officials were present. We will have further engagements, of course, and we may, under certain circumstances, invite the department back, the National Department, that is, to assist us when we prepare our negotiating and final mandates. So with that said, the department, the National Department, and our Provincial Department and our legal team on the platform, you are welcome to exit the meeting. The committee will then further deliberate in terms of this piece of legislation as to how we're going to proceed from today. And then we have also committee documentations and matters that we need to conclude. So you are welcome to leave, and may you all who are departing our meeting have a wonderful day forward. Thank you.
Thank you.
Thank you, Chair. Thank you, Chair.
Thank you, Chair.
Thank you, Chairperson.
Thank you. Yeah. So, colleagues, and then it is only us left. As I stated at the start of the meeting, we just received this piece of legislation. We simply just don't have time in this sort of quarter to do anything, and I think with this piece of legislation, unfortunately, has to stand over for the new quarter next year. And also, I'll recognize Anbo van der Westhuizen. Okay, I take your hand, Anbo van der Westhuizen.
Yes, thank you, Chair. Chair, as Chair of another committee, which this afternoon will be receiving a presentation on the Marine Pollution Amendment Bill, and another presentation next week on climate change. I think what we all know is that legislation is going to come thick and fast to us now before the end of this term. So I was just wondering, I don't think there's anything prohibiting us from today already authorizing you and the procedural officer to go out on a public participation process, because we are running out of time, and I'm really concerned about that in terms of established practice, and I think there's also court pronouncements on this. We are not supposed to count the days between the 15th of December and the 15th of January as days that, you know, would count for real public participation. But I was just wondering whether we shouldn't authorize you and the procedural officer to go out with the public calls or the calls for public comment, so that can be published as soon as possible, so that at least outside of those days between the 15th and the 15th of January, that one would be able to at least provide for enough opportunity for the public to comment. I am concerned that we may eventually end up having to consider legislation into periods of recess, etc., if we do not move quickly on this item. And I wouldn't like the Western Cape to be seen as one of the provinces that frustrate national processes in the National Council of Provinces. So that would be my proposal, Chair, that you are mandated to go out, you manage the budget of this committee, and for you to decide, you know, whether you want to go only for an Afrikaans and English weekend paper, or whether you want to go for you know, electronic means of communication, or a combination of that, as long as the committee afterwards is satisfied that you know, the public had been informed of their opportunity to comment. But that would be my proposal, Chair, that you do consider advertising. Thank you.
Thank you, Honourable van der Westhuizen. And I think I just need to mention is that received communication from the Speaker's Office that they've also referred the Rail Transport Safety Act bill to the committee. We haven't seen it. Johan, have you received it perhaps?
Chairperson, no, I have seen the referral, but not the actual act or the bill. But I'll follow that up and get that to the members as quick as possible.
Okay, so it's a rail safety amendment bill. So in line with the suggestion of Honourable van der Westhuizen, and I think that if we're going to do that, follow that route, and it's possible that we could. I don't know how much money we have in the budget, but that we should include both bills, because whether we receive it this term I don't think that we're going to have a briefing on it or anything of the sort, or whether we're going to receive it next term. It has to be dealt with, of course. So the Rail Safety Amendment Bill is a very important bill. Johan and I, we're with the agreement of this committee, then look at both bills and consider the sort of advertising of those bills for public comment. Just can I get your feedback with regard to that? Are you in agreement with that, colleagues? Honourable Seleku?
Thank you very much, Chair. No, Chair, I'm in agreement that we should, if an opportunity is there for us to go out on and advertise for public comments, then definitely, Chair, we must use that opportunity. And then when we come back from recess, then we can see whether we can have physical hearings. But let us utilize the opportunity, because there's social media, there's Facebook, there is WhatsApps, there is a lot of methods or methodologies that one can use to solicit information or comments pertaining this particular bill. Thank you very much.
Thank you, Honourable Seleku. Honourable Nkondlu?
Chair, I would also support the approach if indeed we would ensure that all possible avenues and also recognize the 3 provincial languages to be used in the province for such advertisements, including, I think, as Member Seleku says, social media. So that at least we can ensure that the net is thrown as wide as possible. So I would support that, including when we come back, considering what has been the submissions, to still have room to ensure that we try as much as possible to ensure sufficient public hearings. So I support with those few additions. Thanks, Chair.
Thank you, Honourable Nkondlu. Honourable van der Westhuizen?
Yes, thank you, Chair, and thank you to the colleagues for their support. I can just say that we also intend to put one advertisement for both the marine pollution and the climate change in the newspapers. There is, however, a standard practice in that briefings or presentations, as we've had today, precede those advertisements. First, there's a briefing at the NCOP, which we're invited to attend nowadays, but often when it clashes with our program, we then ask them for a separate briefing, and normally the advertisement only follows suit afterwards. But as they say, crazy times call for crazy solutions, and I am concerned that we are going into a season where we perhaps may need to be very innovative in order to be able to deal with the volume of legislation that I anticipate provinces will have to deal with. And then just one question, what is the program from the NCOP? What are their due dates? Have they indicated any dates for negotiating mandates, final mandates, etc., regarding these 2 bills? Thank you.
Thank you, colleagues, for your input. To my knowledge, there's no indication as to when negotiating mandates are to be submitted. I don't know, Johan, have you heard anything?
Thank you, Chair. No, the program is only up to the 4th quarter, well, to the 4th quarter this year. The only indication I got from our counterpart on that side was that from the NCOP is that they will deal with it within the first term of next year. So there is no specific dates yet allocated to any of these our two legislations anyway.
Okay, thank you so much. Adam Kunlu, is that the legacy?
Yes, Chair. Apologies.
Okay, no problem. Thank you. Okay, so what we're going to do, once we receive the Rail Safety Amendment Bill, we will circulate that amongst members. As Honourable van der Westhuizen has correctly stated, abnormal times require abnormal processes. And then Johan and I, we in consultation with the members of the committee, present a plan in terms of how we're going to take these two bills forward by round robin, and we can approve it when and how we're going to advertise for public comment. And then we, in the new year, we will then schedule, and once we have clarity also on other dates, we will schedule possible public hearings wherever the need is. And I think, as Honourable Kondlu and all the members, of course, very conscious about our legal duty to have as wide consultation and engagement of the public with regard to the passage of legislation. So that if I have acquiescence from the members, we'll take it from there. Okay. Right. Thank you. And then, colleagues, what was also circulated amongst members are committee reports and minutes of our meetings which we had. We have minutes of the 23rd of August that needs to be adopted. We have minutes of the in October, I think. Let me see. Let me just get to it quickly. Minutes. Yeah, then we have minutes of the 30th of October that needs to be adopted. Those minutes were circulated to members. And then we have the quarterly report that was also submitted to members, as well as the tracking document. I put all of those documents to members. If you have any corrections, amendments that you'd like to highlight to me, or any questions you'd like to ask with regard to those reports and minutes, opportunity now to raise it. If not, can I then have a proposal that we accept it? I'm happy with it as is, and the seconder. I recognize Honourable van der Westhuizen.
I propose that we adopt.
Okay, it's a proposal. Could I have a seconder? Thank you.
Seconded, Chair.
Thank you, Honourable Seleku. So those two sets of minutes, the tracking document, as well as the quarterly report, they are all duly adopted. And then, colleagues, there's just one other matter that needs to be considered, and that being the report of the annual report process we had earlier this last month. So that report also was circulated. It consists of 4 pages. So remember that we dealt with the report in the context of the old Department of Transport and Public Works. It was about 10. But this report specifically deals with the transport and mobility component of that report, as well as that of GMT. So it does not deal with the other infrastructure component of that annual report that will be dealt with in a different infrastructure committee, standing committee. So are there any additions or any corrections that we need to effect to the report as we also circulate it? Okay. Arnold van der Westhuizen, I recognize you.
Nothing from my side, thank you.
Okay. Nothing. Can we have a proposer and a seconder to adopt the report?
I propose.
Thank you. Is there a seconder? Thank you. We don't need a seconder. Thank you, Honourable Nkondlu.
Seconded chair. Seconded chair.
Yeah. Thank you, Honourable Sleko. And that brings us, colleagues, to the last item on the agenda, that being the resolutions. Since this meeting consists only of a briefing, and we have, considered perhaps, Johan, as a resolution, the proposal made by the members in terms of us taking this particular matter forward. Can we frame it in the form of a resolution?
That's correct, Chairperson. I will rephrase it like that. Yeah.
Okay, good. Any other resolutions that members wish to put forward? Thank you. Well, not really at this stage. Critical. And what from the Westhuizen?
Chair, perhaps we must just get some clarity. There is, I presume, a possibility that the rail safety regulator amendment bill may not be referred to us during this term, and then we must just perhaps give you the freedom to proceed with only this one that is currently in front of us as a committee. Obviously, we would all like to see a saving in terms of our budget by inviting the public in one advertisement to comment on either or both of these bills. But it seems to me as if there may be a danger of only the one being referred during this term. And I would then like to propose that you do proceed, even if the other one is not being referred to us this year.
Okay, thank you. So noted. We will do that. Johan, will you just capture it like that? In the event. Johan? Okay, Johan, you will do that, of course. So with that...
Sorry, Chairperson.
Okay.
Got all tangled up here with the snooze and mute buttons. Chair, the railway safety bill, amendment bill, has been referred to us, so we can deal with it. I have seen the ATC. I think the climate change bill was together with the rail safety bill on the ATC.
Yeah, I saw that too. Yeah. Anyway, thank you. And that would then make our lives a little easier. Colleagues, thank you so much for your participation and engagement in the meeting. And it is much appreciated on Nkondlu for your presence. Also, you always add value to whichever meeting you attend, whether it is your regular committee or SCOPA. Your participation is always valued and highly regarded. From my side, I'd like to express my thanks to Siraj, Ms. Nsipela, for your assistance and presence. It is much appreciated. Colleagues, Johan, natuurlijk baie dankie vir jou harde werk in die agtergrond. Waardeer dit. Honorable de Villiers, thank you for your presence and your participation also in our meetings. And from my side, colleagues, have a wonderful day forward, further, and I'm sure it's going to be one heck of a ride from here on. Thank you so much and all the best for the day. Bye.
Thank you, Chairperson.
Thank you, Chair. Congratulations.
Thank you, Chair.
Thank you, Chair.
Member Mr. Leku is gone. Thank you, Nomfundo. Thank you, Shiraz.
Pleasure.
Thank you, guys. Bye.
Thank you, Chair. Bye-bye.
Siraj.
Nomsi, you finished the recording, huh?
Yes.
Thank you.
Okay.
Chat to you
Siraj.
guys later.
Okay, sure. Siraj. Oh, Siraj. Hey, lady. We are done. Eh?
No.
Hello.
Thanks, so. Thank you.
Okay.
I'm gonna wrap up now.
Okay, sure. Bye.